3, 2, 1.
Hey guys, this is an episode of Scott Talks Law, and welcome to another episode of Scott Talks Law. So in this episode, we're going to talk about the land tenure system in Kenya. So land tenure refers to the terms and conditions upon which rights relating to land are acquired, used, disposed of, or transmitted. And the tenure system refers to the relations among people in the society in respect to the scarce available resources related to land. So the relationship among people in the society is referred to as the tenure system in respect to the essential scarce resources related to land. So the tenure systems are culture specific and dynamic. They keep on changing, and they change as the social, economic, and political situations of the group change. So land tenure ordinarily has at least three dimensions. We have people, time, and space. So there are three dimensions of the land tenure system: time, people, and space. So as so far as people are concerned, it is the interaction between different persons that determine the exact limit of the rights of any person has to a given parcel of land. So how people interact will determine the rights of those people in respect to that piece of land. So these rights are ordinarily and not absolute, since the rules are given, since the rules that govern these rights are absolute and not ordinarily, since there are rules that govern the manner in which persons with the tenure is to utilize those rights. So these rights are not they are not absolute rights. They are ordinary rights, because there are some rules that govern the mode of acquisition of land, the use of those. There are rules that govern the rights to land. So the time aspect of tenure determines the duration of one has to a particular piece of land, while spatial dimension limits the physical area over which rights to land is to be exercised. So we say there are three dimensions of the land tenure. We have time, spatial dimension, and the person or people. So the time dimension refers to that time that this person has that right to land. The duration, if it's adverse possession, that 12-year period will determine. So the spatial dimension limits the physical area over which rights is to be exercised. The spatial dimension of tenure may be difficult to determine in exclusive terms, since different persons may exercise different rights over the same space or different time. So it is difficult to determine this spatial dimension. So because different persons may exercise different rights to land over the same space or of different times. So it is imperative that one understands the land tenure system obtained in Kenya, so as to appreciate the different legal formalities available for the transfer of interest in land under the different land tenure system, the historical event, and the patterns that have impacted the land laws and conveyance in Kenya. So you just need to understand this land tenure system to understand the history that relates to land, the formalities available, legal formalities, and the transfer of interests to land. You must first understand the land tenure system. So, and the historical events that have impacted land and conveyance in Kenya. So there are three main land tenure systems in Kenya as defined by the Constitution of Kenya 2010. So there are three main land tenure systems. We have modern land tenure system, community land tenure system, and private land tenure system. So that is according to Article 62, 63, and 64. Article 62 is about the public land, 63 is about the community land, and 64 is about the private land. So the modern it's also called the individual tenure, public holding, and customary or community land or group tenure. So in advent of the Constitution of Kenya 2010, the Constitution perceives perception have been installed whose effect is to define land and tenure system in Kenya with finality. According to Chapter 5 of the Constitution on Land and Environment, identify 3 land tenure systems. So public land, community land, and private land. So these tenure systems are established in that hierarchy that perhaps also reflects the status of the ranking of the tenure system. So that hierarchy, public, community, and private, 62, 63, and 64. And it perhaps also reflects the status or the ranking of tenure system. So that hierarchy reflects the status or the ranking of the tenure system. So public land tenure system, Article 62. So this system of public tenure system, so the system of public tenure stems from the idea of notion of state or the owner of radical title. So the state is the owner of the radical title under public land tenure. So the public tenure therefore designates the government as private landowner and follows the provision of the Crown Land Ordinance of 1902 as they are subsequently amended and embodied in the GLA, which has now been replaced by Land Legislation Act. So the GLA is the Government Legislation Act, which has now been replaced by the Land Legislation Act number 3 of 2012. So the public tenure therefore is a province of the government, is for the government and land. So the public tenure therefore is a province of the government land or public land. Government land in Kenya is the land that was vested in the government of Kenya by section 200. So Article 62 of the Constitution of Kenya provides for public land to include the following: land which at the effective date was unalienated government land defined by the Act of Parliament in force at the effective date; land lawfully held by any state by the way of sale, reverse, or surrender. So if this land was held by state by the way of sale, reverse, or surrender, that automatically becomes public land. Land lawfully held by any state organ except land that is occupied by the state organ as a lessee under a private lease. So if this land is held by state organ but not a lease, not under private lease, then that land automatically becomes public land. So land which no individual or community ownership can be established by any legal process, and land which no heir can be identified by any legal process. So when someone dies and there's no heir who can identify himself with that particular piece of land, then that land automatically goes to the government. Someone has died and has left no heir, that land automatically goes to the state, and the state shall offer it as a grant. So according to this provision, land which all minerals and mineral oils are defined by law are also public land. Government forests other than forests under Article 63(2) of community land are also defined as public or government's land. Government forests and reserves, game reserves, water catchment areas, national park, government animal sanctuaries, and specifically protected areas. All roads and thoroughfares provided for by Act of Parliament. All rivers, lakes, and other water bodies defined by the Act of Parliament. Territorial sea and exclusive economic zones and seabed, continental shelf, all roads. So this, you cannot establish anything in that particular area because that land has been classified as government land. So territorial sea and exclusive economic seabeds and continental shelf are classified too as the public land. Any land declared to be public by Act of Parliament in line at the effective date or